in the mid-'80s, there were changes to the Family Relations Act. There were significant change to the Divorce Act. The 1986 Divorce Act was called the No-Fault Divorce Act because for the first time in Canadian history, someone could achieve a divorce without having to claim fault. And married people had, knowing this act was coming, had put off significant numbers, we now know, had put off pursuing divorce and resolving issues of child custody access and support because they wanted to proceed under the No-Fault Divorce Act. So in the mid to late 80s, there was a real surge of family law matters hitting the courts. And that causes a real problem because the courts tend to give priority to criminal matters, to civil law non-family matters, and then family matters as a last resort. And certainly child welfare matters, part of the family court system before Family Relations Act matters. And all of that understandable. What that meant is that there became interest by the bench and lawyers who practiced family law as well in looking at what could be done to help families access justice and help to resolve their issues that arise when they separate without having to go to court, certainly without having to litigate. And this was at the same time as the research that I mentioned was happening North America-wide, worldwide really, Australia, England, and throughout North America, that was showing through empirical research that children of separating families were healthier post-separation if the parents could resolve their acrimony and work at parenting their children cooperatively post-divorce or separation. It sounds academically very nice. I really believe it's the case. It's very difficult to do, and that body of academic research was growing and was very compelling. And the courts were, the bench was very compelling in terms of we have to do something about this backlog. And lo and behold, here Corrections Branch had 300 odd public servants who were trained as family mediators.